So welcome to our third and final panel, which is called Evidence of Torture and Armed Conflicts, Afghan Detainees and Other Cases. My name is Craig Scott. I'm presently a Member of Parliament, having been a prof here for some time. Torture is one of the areas I've worked on from a number of different angles, which might show with a question or two that I'll ask, but I won't say anything more than that. I'll introduce briefly all four of our panelists, and then as they get into their own presentations, you'll learn a lot more about each of them because by definition, their presentations reveal the kind of work they've done. But I have Professor Amir Attaran from the University of Ottawa, Professor Canada Research Chair and a bunch of things that have nothing to do with the topic, but also one of the people who in the very early days of sort of the dawning that there might be an issue around the transfer of Afghan detainees in Afghanistan began to ask hard questions and engage in a lot of freedom of information processes and has been at it ever since. Murray Brewster, one of Canada's leading, and I was going to say last remaining, but I won't go that far, leading investigative journalists from the Canadian press and the author of a fantastic book called The Savage War on Afghanistan that I recommend to everybody. Dr. Walter Dorn, who's both of the Canadian Forces College and Royal Military College, all kinds of academic work to his credit. For my purposes of late, he's been doing really interesting work around the whole phenomenon of deniability and how governments hide or conceal paths of accountability. And he may get into some of that today, but if not, it's well worth chasing that work when and as it comes out. And Dr. Chris Madsen, who's a colleague of Walter, who's also a Canadian professor at the Canadian Forces College with an association with the Royal Military College, and is an expert in military law, laws of war, and the editor of one of the leading, if in Canada, the leading manual on the laws of war, dealing with court-martials and those kinds of things. And I do see there's some prop that actually reveals that to be the case. So with no further ado, we're going to go in the order I just introduced everybody. They're roughly been asked to speak for 10 minutes. 10, 11 would be the outside, and I will say a very firm thank you at the 10 or 11 minute mark so that we can get into discussions after that. So we'll start with Amir.
Thanks, Craig, and thank you, Francois, for organizing an absolutely superb meeting. My entry to this topic, as Craig alluded, is that very early on, 2006, I started posing questions about detainees in Afghanistan. Why did I do that? Because I just moved back to Canada from the United States. I'd been on faculty at the Kennedy School of Government at Harvard, and I watched as my fellows utterly twisted themselves in knots justifying American excesses. And the day I returned to Canada, I said, no goddamn way will I let that happen on my watch. So this was a very personal quest. And it led me to a number of interesting activities, I suppose. I was co-counsel with Paul Champ for Amnesty International and the BC Civil Liberties Association in the lawsuit challenging Afghan detainee transfers. That's widely known. What is not known, but I feel I can now disclose, is that I also was the author of the motion in Parliament for the production of papers on Afghanistan that ultimately led to prorogation. So I've been involved in this in some time, and I must say that it was and has been and remains a mostly unavailing exercise due to what I think are fundamental failures of justice in Canada. This talk is dedicated to David Cole because he thought that Canada was superb in this regard. I am going to disabuse him. He's not even here. Anyway, were he here?
He's over there.
Oh, he's over there. Hi. I'm going to disabuse you of that. Well, I can give up then. And I've divided this into 5 parts about how our system failed in the Afghan detainee case. I think the outcome of it was a failure. I think you can't characterize it any other way legally. Politically, it possibly was not a failure because it did cause the government considerable pause over how they handled matters. Failure number one arose because of our evidentiary rules and our penchant for secrecy, which I will get to later, I think is cultural. Here's an example of one of my first information requests. I asked for human rights reports on Afghanistan, and I got this back. Lots of censorship, and Afghanistan still faces immense political, economic, social, and security challenges. I got this through the Access to Information Act and also under the Canada Evidence Act during litigation. Section 38, which can be used essentially with very weak recourse to judicial review. This is what I got. And after years of litigating it, this is what I got. This is the part that was covered up. The last sentence is noteworthy. Extrajudicial executions, disappearances, torture, and detention without trial are all too common. That's what the Government of Canada knew the day they signed the detainee policy. They claimed that disclosing this would breach national security or international affairs. Of course, that's rubbish, because any US State Department report you read or UN report you read in Afghanistan says much the same thing. But nonetheless, they kept it secret, along with much else. Here's the list of detainees who were captured and transferred. Rather forthcoming, isn't it? Here, I decided to pull their leg at one point, so I filed a Freedom of Information request for photographs of the detainees, but only their hairdos. I asked to have the faces blocked out, and I just wanted to see the hair. The answer was that disclosing photos of Taliban hair would breach our national security obligations. Apparently, you know, bad hair, or I don't know, it's something that we wanted to cover up for whatever reason. The point, of course, here was tongue-in-cheek, to show that even the most trivial information requests in Canada are deflected with secrecy. That's the point. But this is what you get under FOIA, the Freedom of Information Act in the United States. These photos are disclosed by American law. Now, how's that? Oh, and this is also disclosed under FOIA in the United States. It's an account of a detainee in Guantanamo who had been, was barefoot, shaking with cold. He'd been nearly unconscious. He was so disturbed, he'd been pulling out his hair during the night. The Americans will release this kind of thing. The Canadians won't. You get this instead. Pardon me, you get this instead. That's a cultural reality, and it impedes justice in this country. It's not because of substantive differences between our law and their law. I also was expert witness in the British detainee case, and consequently, without breaching what I shouldn't breach, I can tell you that I did review extensive evidence of Britain's detainee transfer. There's an implied undertaking, I can't tell you what I saw, but I would say that the amount of British censorship compared to Canadian censorship in much the same matter, probably 95% less censorship in Britain, perhaps as high as 98% less, but a very big difference. So that's one problem. We're secretive, even when the law says we shouldn't be. Another problem is doctrine. We are, to be very frank, backwards in our international law application in this country. As others have said, Craig said it, and Kent said it as well, the courts have decided in this country that violations of foreigners, i.e. Afghans' charter rights on Afghan soil is not a matter justiciable under the Charter. They have no such rights. In the in the Council of Europe, that is not the case. There are about 50 countries in the Council of Europe. It's bigger than the European Union. It includes countries like Russia, which are bound by jurisprudence that says the actions of a foreign military on foreign soil are subject to the European human rights norms. That's true in Britain. It's true in Russia. Doctrinally, Russia is ahead of us. Okay? It's true in the United States. Habeas rights apply in Guantanamo. Now, it's a very limited example, but you know, habeas is constitutionalized. Guantanamo is Cuba. So we are behind both those countries in the recognition of rights of foreigners on foreign soil. I think this is because we actually have a problem of judicial courage or lack thereof in this country. Let me be completely frank. The Supreme Court of the United States has heard detainee cases on at least 3 occasions, Hamdi, Hamdan, Boumediene. The UK has heard detainee cases. The House of Lords, now called the Supreme Court, has heard detainee cases on a few occasions, Al-Skaney being the most prominent. Our Supreme Court denied leave to appeal on the only detainee case it's ever seen. Now, the test is whether there's sufficient public interest. In our leave application, we filed 70 days worth of debates in Parliament about this issue, 70 days worth of Hansard. But I guess that's not enough public interest for the Supreme Court to hear it. Why would they bother? And the fact the issue was new, why would they bother? So let me be completely blunt. The Supreme Court put its head in the sand, deeply, okay, deeply. Is that to say that they're cowards? Yes. Okay, and I may cause offense by that, and I'm not particularly concerned. Is this cultural? Yes. I'm an American by birth. I chose to come to Canada after being schooled in the UK. I took Canadian citizenship. I love this country deeply. I could have probably lived in other places, but I chose here. Having been raised somewhere else, having been educated somewhere else, what I can tell you is I see things about this country that surprise me. It's an interesting experience to learn a country through its laws, which is what I did. I came here for law school. And what I can say is that I elaborated this in a literary review of Canada piece called The Ugly Canadian a few years ago. The flip side of Canadian politeness, which is delightful, is an almost pathological preparedness to avoid difficult issues and conflict. We are so polite to a fault that when difficult issues come up, we will go turtle. That's the way we are. And that normally reduces friction in our society in a beneficial way. But if you are Meher Arar, or an Afghan detainee rotting in a cell somewhere, you probably would have liked a bit more open conflict about your issues. I'm just hazarding a guess. Probably have only 1 minute left. My 5th and last point. I don't think that there's going to be any justice done on the Afghan detainee issue anytime soon. But I do firmly believe, and I think it's actually not controversial, that there are certain persons in the bureaucracy and in the military of Canada who committed acts that would be war crimes, aiding and abetting torture, transferring a person to a known torturer when you've got evidence on an ongoing basis that the torture is occurring, is a war crime. So without any apologies, I'm going to say we live in a country that is very peaceful, but that does include a few war criminals. I don't know who they are. I don't know their names. But for the events that happen to happen, persons must have committed offenses. It is a salutary exercise for countries to eventually work this out. We will not work it out tomorrow, or 5 years from now, or 10 years from now, perhaps. But I believe we could in 20 or 30. And I think that is actually worth doing. What I would propose to other academics here with a similar interest is, we will be retired, we'll be on a beach in Florida somewhere, I don't know. Others will have to do this. Let us prepare a time capsule. Let us put all of our knowledge about what happened in this event into a digital repository or a book or both that is there for the use of prosecutors perhaps decades from now. I think that will be salutary for this country. History and truth normally is, even when it's hard. And I add to that time capsule project a broader observation that has nothing to do with Canada. In the past decade or so, there have been a great many excesses in the global war on terror. This is not the only one. I would like there to come a day when the new states of the Arab world demonstrate their democratic credentials, which I hope they will acquire, because right now it's looking rather ropey, by turning around and prosecuting Westerners for war crimes. When they do that, We will, of course, be scandalized that we're in the dock. But take one's emotional reaction out of it. What it really means is that they have arrived as democracies and that the global rule of law is stronger. This will be salutary. And so to the extent that we can, as a foreign aid, as a development project perhaps, catalyze thinking in newly democratic Arab states to essentially take up cases vindicating the rights of their citizens who were the victims, this would be a useful academic project, although a very controversial one. Thank you.
Well, thanks, Amir, for your characteristically timid and low-key presentation. Murray.
How do you follow an act like that? Thank you very much, ladies and gentlemen, for coming to listen to this. And thank you very much, Francois, for organizing this. It's been marvelous. I'm particularly happy to be sitting here and talking to you about Afghanistan, but also about this subject. The reason being, as from a journalist's perspective, and I think my colleague Colin Fries will agree, that Afghanistan, which seized the public agenda, seized the political agenda in this country, and seized the debate in this country for the better part of 5 to 7 years, has almost completely disappeared off of the public radar. And I'm of the opinion that when you send young people off to war, that they not only deserve, their task not only deserves a fulsome debate ahead of time, it also deserves a fulsome debate afterwards. And I found Amir's comments about the Supreme Court of Canada sticking its head in the sand to be actually quite appropriate, because I believe that not only has our political establishment stuck its head in the sand, but so too, to a lesser extent, has the Canadian public. I saw one person being quoted in an article, I believe it was this morning, talking about the situation in Mali and comparisons to Afghanistan, and talking about how the reluctance to become engaged in Mali is largely due to Afghanistan and the war weariness of Canadians. My experience in Afghanistan was I spent 15 months there over the 5-year combat mission. The rotations that CP sent me in on would last 2 to 2.5 months, sometimes 3 months. And during that time, I was rocketed, shot at, and summarily chased through the streets of Kandahar, sometimes by the Taliban. And I've been to Saraposa prison. I've been to the NDS headquarters. I've seen captured Taliban fighters being led away. So my experience has been mostly at the coalface of this. But also, too, the other part of my duties when I wasn't in Kandahar, I was in Ottawa covering that aspect of the war. So I was at the coalface there. And I would say that I've had a unique experience on 2 different war zones that I can offer you. But I guess there are a few things I think that need to be understood about Kandahar and about the situation that we found ourselves in on the ground. First of all, I would suggest to you that the Canadian military establishment, the Canadian government went in to the Kandahar mission in particular completely blind. They went in with very little intelligence. They went in with very little understanding of, and even elementary understanding of the political dynamic that was on the ground, who the power brokers were, what the situation was, and I wouldn't necessarily say that they didn't understand what was going on in terms of human rights, because there were just an absolute plethora of reports from the United States State Department, internal government documents that talked about the human rights abuses that were taking place in Afghanistan. But what really wasn't genuinely understood, but what became very evident to me in only the first week that I was on the ground in Kandahar in 2006, was that society in southern Afghanistan, in particular, had almost entirely broken down. We take for granted the police forces, and we've talked about today their excesses there, but we take the rule of law here for granted. In Afghanistan, and in Kandahar in particular, in 2006, society was absolutely, and in my estimation even today, continues to be so shredded, so down to almost the most basic level, that it is almost unrecognizable to us. And let me focus in on the police for a moment. There were Afghan police, and there has been, as you probably are aware, a massive training program undertaken by NATO to train a somewhat credible force. But the Afghan cops that I ran into in 2006 were nothing more than illiterate ex-militia fighters who slept on straw and whose police stations were nothing more than shells, were nothing more than half-completed buildings where they had to borrow electricity and they had no running water. And in one instance, one police substation had one serviceable AK-47 for 21 officers. This was the thin blue line that the West was expecting to enforce law and order. And one of the things that I found absolutely incredible was that many of the police officers in Kandahar, many of these militia fighters, obviously they couldn't read, so therefore they could not read the laws that they were being required to enforce. It was utterly amazing. And it is within that context that I cannot understand how the decision that Canada came to transfer captured Taliban fighters into the hands of not only the National Intelligence Service, but also local police. This, again, I come back to the notion that this was a society that had been at war for 30 years. Many of the Afghan cops whom I've spoken with had lost relatives to the Taliban. Now, taking out our innate sense of justice out of it and rule of law for just a moment, you have to understand that these people, the Afghan people, have been completely traumatized. They live, in many respects, by a different code, the Pashtun-Wali tribal code, which dictates, in some cases, vengeance. I think we have, in some respects, and this is not excusing torture in any way, shape, or form, but I wanted to at least emphasize to you just how utterly destroyed that part of the world was, and how it seems incredible to me that our leaders, both political and military, thought that it was appropriate and that the people whom they were handing over, in many respects, were going to be well treated. There's one side point that I want to mention. There's been considerable debate in Canada about whether torture occurred and how often and who it was and who was the perpetrator, et cetera. From my experience on the ground, and I think other journalists would agree with this, being able, at this point in time, to get an accurate either assessment of individual incidents or just plain evidence is very, very difficult because of the security situation on the ground, because of the conflicting agendas and also because of the language and cultural barrier. There's been a lot of talk about, about the possibility of, trying, people potentially for war crimes. And I would suggest to you that that is going to be a forensic investigation that is the equivalent of Mount Everest in terms of being able to actually get information, and I'm speaking specifically about Afghanistan. I'm not saying that it is impossible, but I would suggest to you that it is going to be very, very difficult to get evidence that will be accepted either by an international court or a Canadian court or even for a public inquiry here. Now, the reason that I say that is I'm going to give you an anecdote, and it involves an attempt by the Canadian press in 2010 to track down possible Canadian transferred detainees who might have been tortured. And I'll keep the explanation brief, but essentially, we were having to act through our fixers, our local drivers and translators, who acted as our guides, but they could only go so far. There were people in Afghanistan who were purported human rights advocates who were willing to provide and allow us to meet with people who had claimed that they had been tortured. And there was a project that was going on separately. An organization in Canada was looking for these people at the same time that we were. And we ended up meeting with these people. We ended up meeting with this intermediary. This intermediary, the moment he found out that I did not represent the organization that he had been promised to deal with in Canada, and I was only a journalist, and I didn't have a lot of cash to spend, the interest immediately evaporated. So that is only one example that I am prepared to share right now of how the process could potentially be tainted if there is a forensic investigation that follows into what happened over there. I'll give you a short summary of how, I'm sure a lot of you are familiar with the case of how this unfolded. It was, national news for years at a time. So I won't repeat most of what's gone on, but there are a few troubling facts that I don't think received enough light and enough attention during that time. And the question of why did Canada, why did the UK, why did the Netherlands transfer captured prisoners back into Afghan custody? The most basic question, like why were we doing this? Well, one of the reasons why is because there was willful blindness. I think everyone, and it was evident to people who were close to this while it was going on, that there was a huge risk of torture. But at the same time, too, I would suggest that there was an institutional laziness that was a part of this. Because early on, there was a proposal by the Netherlands that Canada, the UK, and the Netherlands construct under NATO's auspices a detention center where they could hold on to prisoners because of the possibility of torture. And Canada, and I have this under access to information documents and reported it in my book, but essentially, Canada put the kibosh on it because it would take resources away from the fight. It would have taken combat resources away. It would have been an administrative burden. That I found to be incredibly troubling. Incredibly troubling in the sense that in this country we're all raised and steeped in the mythology that we always try to do the right thing. And for us to have kiboshed the attempt by NATO to establish its own facility was deeply disturbing. There was also the aspect of the policy of when Canadians signed their agreement with the Afghan government that there would be no recourse. If someone had been captured, they would be handed over, but there was no right of follow-up. Unlike the British, unlike the Dutch, Canada didn't follow up on its detainees, and the government had to be dragged kicking and screaming to once again do the right thing because of a Globe and Mail investigation in the spring of 2007. You have to ask yourself again, why? Why did the government have to be dragged kicking and screaming? Well, part of the answer, as far as I'm concerned, is, bureaucratic sclerosis. The only way to describe it is because they knew about the problem. It's evident, it's documented. If you go before documents that were placed before the Military Police Complaints Commission, the government recognized as early as the fall of 2006, never mind the testimony of Richard Colvin, the government itself and the bureaucracy recognized there was a problem. But of course, the bureaucracy is all about process. The other aspect, the one that is more troubling, and it's sort of been touched on in other presentations here today, is the sort of what I've come to term as the trash talk. The attitude of who cares if Afghans are torturing other Afghans? It's none of our business. They're not human. They're monsters. They've been killing, our soldiers. And this isn't the sort of stuff that comes directly out of the mouths of politicians. My own brother-in-law happened to say the same thing after reading my book. What occurred in Ottawa between 2006 and 2011, when it came to the Afghan detainee controversy, was, in my estimation, as a Canadian, as a thoughtful individual, was utterly scandalous. Because essentially what we witnessed, why the government took the course that it did, was because it was good wedge politics. It was the kind of comment, the kind of us versus them mentality that excited their political base. And it also enticed their opponents to attack them further, enhancing their position among their supporters. Now, I guess I would like to conclude by saying that Amir questioned whether or not any good has taken place here, and I'm going to leave you with two anecdotes. Well, actually, one anecdote and one story, but essentially, I would suggest to you that the government, and I include both the political aspect and the bureaucratic end of it, felt so burned by their experience in Afghanistan that they will think twice about becoming involved in other foreign adventures. The example that I hold up to you is a story I wrote about 18 months ago. And it talked about how the current government was very eager to see Canada play a leadership role in other military operations in a similar manner to the command that Lieutenant General Charles Bouchard had in Libya. And one of the proposals that was in front of the government was to command the Naval Task Force that patrols off of East Africa and attempts to stem the piracy that takes place there. And one of the aspects that the government has wrestled with, and I would suggest it has overshadowed most of the discussions, if the documents obtained under access to information are to be believed, but one of the aspects has been the concern about detainees. What do we do with the pirates that we capture? Where do we try them? How do we do it? And the document trail essentially showed that it was one of the reasons why Canada has stepped back somewhat from that. The other is an anecdote that I will share with you that is somewhat more personal. There are many occasions where I had the opportunity to have conversations with NDS officers. For those of you not quite familiar, the NDS, the National Directorate of Security, is the intelligence arm of the Afghan government, and it is the one that has been at the center of the torture allegations. I've talked to many NDS officers, both in the presence of Canadian military officers, but more importantly, when I've just been with my fixers. And they're quite open about talking about the detainee controversy in Canada. And what they have said, and if it is to be believed, and this is from several different NDS officers, it's that because of everything that has happened here, because of the human rights complaints, because we have been so vocal about it in this country, that Canadian captured prisoners have been treated better than others. Now, whether that's a victory or not, I don't know. I leave that up to you to decide. But it is something that's come from several NDS officers. Anyway, thank you very much.
Thank you, man. Walter.
Heavy. Chris Madsen and I teach military officers at the Canadian Forces College, and I hope none of them are war criminals. But we do have to say that we have the unenviable history of teaching someone who committed torture in Canada and murder in Mr. Russell Williams, who was formerly a colonel and in the Command and Staff Course. At the college, we try and instill critical thinking to the officers on international affairs and armed force. We give a lecture on the ethics of the use of force. Chris teaches laws of armed conflict. And at the college, we feel that you have to learn from the lessons from the past, both good and bad. And Somalia is one of the important cases where torture was conducted by Canadians, by Canadian non-commissioned officers. It's no longer used as a case study, but it must not be forgotten. And I'll provide a brief overview of the Somalia case of torture and the aftermath, and then, time permitting, I will draw some comparisons to the Afghan detainee issue. On March 16th, 1993, Canadian soldiers in Beledweyne, Somalia, discovered a Somali teenager, Shadain Aron, hiding in an abandoned American base across from the Canadian base. Because of previous Somali attempts to steal from the Canadian camp, the airborne soldiers, that is, soldiers from the airborne regiment, detained him despite his protests that he was searching for a lost child. Later that evening, Master Corporal Clayton Matchie of the Canadian Airborne Regiment began to pour water, experimenting with this detainee in what we now call waterboarding, until the guard objected. But when a new guard, Private Kyle Brown, took over, the old guard simply stated, quote, "I don't care what you do, just don't kill a guy," unquote. A killing would trigger an automatic investigation by military police. When Matchie went to the mess for a few beers, he boasted to others about what he intended to do. Another soldier suggested the use of, quote, "a ration pack or phone book to beat the youth, as it would not leave any traces," unquote. Matchie and Brown then proceeded to beat Aron with a ration pack, sodomized him, tortured him in ways that are not suitable for description. Brown took trophy figures. When another master corporal arrived, Matchie showed him the semi-conscious Somali, boasting that, quote, "in Canada we cannot do that, but here they let us do it," unquote. Many Canadian soldiers could hear the screams or observe the beatings, but none intervened. Aron finally fell unconscious after hours of beatings. His last act was to shout "Canada" 3 times. After Brown mentioned the beating to a superior officer, the base medics were called and confirmed that the teenager was dead. An investigation by military police led to the detention of Matchie and Brown 2 days later. In the base detention facility, Matchie attempted to hang himself. When medics rushed him on a medical stretcher to the medical tent, a reporter from the Pembroke Observer happened to see the commotion. He received a put-off response to his queries, so he began asking more questions, and he then was the first to report the death of a Somali citizen in Canadian custody. This was the beginning of the public's exposure to the unfolding Somalia affair. The immediate military response to the act seems proper. Matchie and Brown were charged with murder, 2nd degree, and torture. Matchie was declared unfit to stand trial due to the serious brain damage from his attempted suicide and was later released from military service. Brown was convicted to 5 years imprisonment, though released on parole after serving only 1 year, and he was dismissed in disgrace from the military. He subsequently wrote a book to claim he was a scapegoat for the faulty orders and procedures created by superiors who had encouraged his behavior. 7 other military personnel from the base were also court-martialed. 2 were convicted of negligent performance of duty and sentenced to short-term imprisonment and dismissal. The other 4 were acquitted, including the commanding officer. The larger story is about responsibility at a higher level, including the military actions prior to deployment. Questions arose. What kind of preparation, training, and leadership was provided in the Canadian Airborne Regiment and in the Canadian Forces more generally? How could this situation have been allowed to happen? Questions even went to the political level. The Minister of National Defence, Kim Campbell, who was in a race to become Progressive Conservative leader and Canada's Prime Minister, early on dismissed the allegations. She was also blamed for a slow response, taking 5 weeks before a higher-level investigation was ordered. And the Military Board of Inquiry was criticized because of its proceedings, which were held in camera, out of public purview, and with narrow terms of reference. Because of a whistleblower, a surgeon on the base, it was soon discovered that the airborne had killed another Somali 12 days earlier, on March 4th, 1993, using food as bait to lure Somalis into the Canadian camp. But it was only then that the real cover-up began, when a CBC reporter requested documents on the military operation under the Access to Information Act. The documents were altered, and the fee to procure these documents was outrageously inflated, $4,000. When a publication ban on the photographic evidence of torture was lifted in November 1994, the Canadian public was shocked by what it saw in the media. This public revulsion was only heightened by videos released of disgusting airborne hazing rituals and racist displays. Under immense pressure, the new government of Jean Chrétien created the Somalia Commission of Inquiry in 1995. The hearings were broadcast daily so the country could follow as military brass sought to openly defy the commissioners. Many in the military felt the commission was complicit with the media in a witch hunt. The government decided to disband the entire Canadian Airborne Regiment in 1995, an extraordinary act even in the cost-cutting atmosphere of the day. The Chief of Defence Staff, John de Chastelain, did not support the government's decision and resigned under a cloud. The next CDS, Jean Boyle, resigned a few months later after he blamed his subordinates for wrongdoing and the forging of DND documents. Even the Liberal Minister of Defence, David Collinet, was forced to resign in part because of the Somalia affair. The inquiry became bogged down in disputes over the military, over unprovided and tampered documents. The politicians were feeling the fallout. It was reaching into the upper echelons of the military civil service and the political arena. Shortly before the 1997 election, with the Liberals unable to blame the Conservatives for all the problems being exposed in the Somalia inquiry, the government cut short the inquiry to the 30th of June, refusing the inquiry's request to continue to the end of 1997. The government blamed the commissioners for exceeding their mandate, spending too much, and taking too long. In the end, the inquiry did not even get to investigate the acts of torture that had sparked its creation, nor was it able to examine top-level government decision-makers. Well, coming to the other case of concern here, Afghanistan, there are strong similarities with the Somalia situation. One, the investigating bodies in both cases were not able to complete their work, even as new and unflattering details were being revealed. Neither government liked bad press. Both faced elections. The truth suffered because the public was not able to get to the bottom of the problem. Two, the top brass constantly sought to downplay the problems. The CDS Hillier, in the recent case, was dismissive of any possibilities of Canadian detainees being tortured by Afghan authorities. He felt his sparse executive agreement, which had no verification provisions, as noted, would be enough. His successor as CDS, Walt Nathanson, to his credit, corrected himself immediately after finding out that an Afghan beaten by Afghan forces had indeed been in Canadian detention. Three, insiders who spoke their conscience played an important role in the discoveries. For instance, the 4th of March 1993 bait and kill operation would likely not have come to light unless a soldier wrote about the execution, as he called it, in an anonymous letter to MP John Bruin, who read the letter aloud in Parliament. Also, military surgeon Barry Armstrong challenged his superiors about the death of a Somali on March 4th. Seeing that there might be a cover-up, his wife even provided testimony and triggered a public outcry that resulted in the inquiry. Similarly, the testimony of diplomat whistleblower Richard Colvin in the Afghan case played an important role in shaping opinion on what was likely happening in Afghanistan. But there are also significant differences. Thankfully, no Canadian soldiers were directly involved in torture in Afghanistan, according to any evidence we have. The accusations are only that the CF turned over detainees to Afghan authorities who might subsequently torture them. Such complicity would, if proven, violate the laws of armed conflict and the 1984 Torture Convention. Two, there are no string of resignations for actions in Afghanistan at the top military or political levels, despite calls from the political opposition. So to conclude, despite the differences, acts of torture was involved in both Somalia and Afghanistan. The government has a responsibility to reveal the whole truth and nothing but the truth, to make sure no complicity in the past or for the future when Canadian forces are deployed. We owe it to the Canadian Forces personnel deployed for honorable service on operations to know that their colleagues, are not complicit in torture. Any wrongdoing must be exposed. We also owe it to the Canadian public, to the international community, and to the values that we hold dear. Thank you.
Yeah, just to follow on Walter's presentation, I'm not a practitioner. Never belonged to the military, never been in uniform, but have been associated with D&D for almost 20 years now, and have worked with them very closely. I was essentially brought in post-Somalia to really revise a lot of the legal curriculum and work with the military legal officers to really integrate training and education in the law of armed conflict for my first 4 years at the college. I'm an academic with an interest in military judicial behavior and sentencing trends, primarily in courts-martial as part of the military justice system. My focus isn't necessarily on the mechanics of military law. There was a major review after Somalia by Justice Brian Dixon. There have been 2 5-year reviews by retired Chief Justices. They very much focus on the mechanics and what military justice should be. My work is primarily looking at how military justice actually works based upon hard empirical data. I've looked at about 4,000, digested about 4,000 courts-martial since 1972, which is in this book, published by Carswell now. One of my majors who took the military law course a few years called this Professor Madsen's Book of Shame. Hasn't stopped from a few of my students actually getting in here, but certainly it's really the only place where you can find any sort of data and hard information about courts-martial. Most of the information is kept in various ways and stored up in the closed-stack library up in the JAG library up in Ottawa. And this is really the only place where you can get the hard empirical data. Really the focus of my presentation today is to look at how the Canadian military has handled torture in the past and likely how it would handle torture in the future based upon the military justice system. Walter's stolen a little bit of my thunder, but soldiers torture for all sorts of reasons. As it was mentioned in the second panel, soldiers will torture to gain information, gain advantage over an adversary. Sometimes soldiers torture because they're ordered to, directed by their superiors. Sometimes they torture to teach a lesson. Detainees that are captured inside the wire, they teach them a lesson. Sometimes they're tortured for sport, as in Somalia. They liked it so much they took pictures of themselves with the tortured person as they were killing him, as in the case of Brown and Matchie. Sometimes they torture to give themselves a sense of power over the weak and the defenseless. And ultimately, they also torture because they derive pleasure from it. Certainly Colonel Russell Williams, who Walter mentioned, had this sexual machoistic pleasure from not only the torture of a civilian, but also one of his own subordinates in military uniform. So there's all sorts of different reasons why soldiers torture in the military environment, but at the same time, the Canadian military takes all sorts of efforts to try and to instill in them that they do need to maintain discipline, they need to maintain the rule of law, and ultimately be responsible to the laws of the land. As Walter said, Walter's given a very good summary of the Somalia cases. I'm primarily going to look at three groups or clusters of case law. One is from the Somalia inquiry, Somalia events in 1993. The second was a very related event in Haiti in 1997. And I'm also going to look at the case of Captain Semra from Afghanistan in 2009. As Walter mentioned, Private Brown received 5 years. As it was mentioned this morning in the first panel, torture is a criminal code offense with a maximum punishment of 4 years. But as you heard in Walter's presentation, Private Brown was given a 5-year sentence and dismissal with disgrace. It actually went to the civilian appeal court, the commercial appeal court. They thought that that sentence was a bit on the lenient side, but ultimately upheld that sentence. And as you heard, military authorities released Brown a little over a year into a sentence. That's pretty typical for these type of offenses, serious offenses in the military justice system. Master Corporal Matchie, ultimately the charges were dropped in 2008 after several attempts to determine whether he was even fit to stand trial. Ultimately, the military decided that he wasn't. There was also a cluster of 3 courts-martials for the immediate supervisors, Private Brocklebank, Sergeant Boland, and Sergeant Gresty, that either observed the torture taking place or didn't take steps to interfere in that torture. Ultimately, one of them was given 90 days detention, but the other 2 were found guilty. There's another cluster of courts-martials for the immediate commanding officers, or the officers that were involved in that. Captain Socks, who was given a severe reprimand and reduction in rank. Major Seward, who was given a severe reprimand, but again, that went to the court-martial appeal court. And because Sergeant Boland had received 90 days detention, the civil judges and the court-martial appeal court ultimately bumped that up to 3 months detention and dismissal from the service. There was also a cluster. It's interesting, it's on the periphery, but there was a cluster of courts-martial involving the falsification of documents and the destruction of documents out of the Somalia inquiry. Commander K received a reprimand and $2,000 fine. Colonel Hazel, who actually admitted to destroying documents, was found not guilty. Corporal Purnell was a whistleblower that looked at some of the events that took place in Somalia. He was ultimately given a severe reprimand and a $2,000 fine for whistleblowing on the events which were taking place. It's interesting because courts-martial have about an 83% conviction rate. A large number, there's about 60 to 70 courts-martial per year, tried by 4 dedicated military judges. But about 2/3 of those cases every year go through a plea of guilty rather than a full-scale trial. So ultimately, a lot of the work that military judges do is simply determining appropriate sentences, and there's a lot of toing and throwing between defense counsel and prosecutions about what an appropriate sentence would be. And ultimately, there's also a decision whether certain charges, particularly criminal charges, will be withdrawn for lesser offenses like service offenses. Some defense counsel, David Bright in Halifax, John Oslin in Montreal, and Dan Murphy in Victoria have sort of built up their practices on pleading out soldiers at military trials. In terms of Haiti, it was very similar to what was talked about in the first panel in terms of the actual people who committed the trial and the captain who allowed these things to take place. Essentially, they were tried for not torture, but for assault, criminal negligence, other things under the criminal code. The two immediate people that did the torturing received a reprimand and $500 fine. In one case, in the other case, Sergeant Pinnell was a reprimand and $1,500 fine. Captain Langlois, similar to Captain Socks and Major Seward, ultimately the military, after several tries at trying to try him, and it went to the court-martial appeal court that sent it back for retrial, essentially decided that that the space of time had taken so long that he simply withdrew the charges. The defense counsel will often do that if putting in a plea and bar of trial or some sort of charter motion to have a stay of proceedings. In the Afghanistan case, I'm just going to go over these briefly because of the shortage of time. Captain Semra, many of you might be aware because it was covered very fully in the press. Captain Semra was accused of allegedly killing a detainee after capture. The prosecution claimed it was for mercy purposes. We don't know because Captain Semra refused to disclose why he did it, and he's even written a book now and doesn't talk about why he did it, but again, just like Private Brown, talks about why he's a victim of the military justice system and the military authorities that somehow went against him. Ultimately, Captain Semra was found not guilty of murder in the second degree and attempting to commit murder, but was again convicted of a lesser service offense, behavior in a disgraceful manner, and given essentially a reprimand, reduction in rank, and dismissal from the service. What you see in how the military justice systems handles these cases is that there's a lot of leniency. I wouldn't say leniency in the sense, but there's a perception. Military justice exists to set an example, maintain discipline, maintain the military hierarchy. It's structurally within the general courts-martial system where you have a panel of military members. It's not analogous to a civilian jury. Sometimes the reporters will call it a civilian jury, but essentially those military officers are there to assert the authority of the military over the individual. And certainly in the application of military justice, often the interests of the institution or the group overtake what happens in terms of the actual outcomes of those trials. At the same time, the military has proven very lenient in terms of once that example has been set, in terms of sentencing, to impose or mitigate, remit the sentences. So customarily, even for the most serious offenses, the chances of somebody staying in a federal prison or even in the military prison in Edmonton are pretty slight. There were a series of murder cases in Germany in the 1980s and 1990s, and those, even though they were given 14 years or 12 years in imprisonment, they were certainly out of jail and into the civil society in less than 2. With that said, given that it's a workshop, and I just wanted to pose certain questions at the end. In terms of the audience, who here thinks that a reprimand or fine or a short term in jail is sufficient punishment for those in military uniform who commit or condone or instigate torture? This isn't just alleged torture. These are people that either have admitted pleading guilty to the torture or have been convicted through findings of a military judge of torture. If you look at the Private Brown case, which is essentially the gold standard for what if any court, criminal court, is going to look at in terms of the military courts are going to look at, if another torture case comes in the future, 5 years is basically the case law for what the standard is going to be. It's not 14 years, it's 5 years, and likely that individual would spend less than 5 years in actual prison, probably somewhere between 1 or 2. You look at because the military treats these cases as sort of a leadership failure, they also go after the immediate superiors or immediate supervisors. Those people tend to only get severe reprimands or fines, and at the highest levels, colonel and above, those task force commanders that Amir at Attaran is talking about, if they ever came to trial as war criminals or whatever under the trial, the case law is that most of those individuals have never been convicted before court-martials if you're going to try them under military justice. Why do we not know more about courts-martial verdicts and results of courts-martial? You know, outside of my book, where do you go to find what the verdicts are? Even the military itself doesn't publicize these types of courts within the military itself. So what sort of deterrent is military justice system if you're trying to prevent the rest of the armed forces from committing these types of offenses? And ultimately, our courts-martial, particularly the general courts-martial, are they the best venue to try serious criminal offenses like torture and murder, given the limitations and the focus that the military justice system has? Or should these types of offenses be tried in the civilian criminal courts, either the provincial criminal courts or in some sort of other venue? So with that, I'll open that up to throw out those few questions to the audience.
We have a fair bit of time, indeed at least half an hour, to engage with everybody in the audience and across the panel. I thought I would just add a few points. Amir, on the issue of truth and justice around the Afghan detainees, in light of the kinds of, whether they're cultural or bureaucratic or other kinds of barriers to knowledge, I'm going to go out on a limb and say I'm not nearly as pessimistic about whether we're going to know, in essence, the truth of Afghan detainee transfer, why it was done, and who's largely responsible for it, well before 10, 20, 30 years. One of the reasons I'm in Parliament is to find the answer to that question.
As soon as the NDP forms government, hopefully sooner,
Yeah.
then I think I'd agree with you.
Well, then the point is that I think the biggest thing that's going to be missing in the story, when all is said and done, may well be where Murray went, which is clearly identifiable and available to testify victims. That will be where the chain will be very, very hard to prove. Now, it's very important to know that not just in the court of public opinion, not just as a matter of morality, but also in courts of law, you do not need a body in order to prove that somebody was harmed in some way in criminal law. In the Semrau case that Chris was just talking about, we don't know who that person was. That person who has no name, he was part of a context, and yet he was still convicted on a very low level for what he had done. So it's important that everybody knows that Graham Smith, in his April 2007 article that helped blow all of this open, he was there at the same time as Murray, and when he basically interviewed, what was it, Murray, 20 to 30? 33 people who had been transferred by Canada and put into detention, with many of them complaining in a way that he found plausible, and he was able to document, of having been mistreated or tortured. We have evidence that there are people who were tortured, who were transferred by Canada. Whether or not any of that can be corroborated enough in a court of law will remain a huge open question. But whether or not eventually Canadians will come to understand that, as Amir said, Canadian decision makers and policymakers were involved in not just creating, but maintaining, even as their knowledge grew of the human rights problems and the practices of NDS, we will know the story of how it happened, why it happened, and who ultimately was responsible. That's my optimistic view about where we'll end up, and I hope sooner rather than later. But it's not likely to happen in the full glory of the light of day until perhaps a change of government. Another thing to note is there has been one judgment that's come down related to detainees of importance. That's the Military Police Complaints Commission judgment, in a case that was brought about whether or not there had been a dereliction of duty by military police in their role, basically just in the chain of custody, of transferring detainees. I have to say personally, just in terms of where I really feel the blame lies in the whole scheme of the policy of transfer, I did not particularly want to see lower level military police, soldiers for that matter, the ones to take the fall for this policy. And so at that level, the fact that nobody was found to have engaged in a dereliction of duty with respect to the system, I certainly can live with that result. But there's some very important stuff in the judgment that hasn't been covered really by the press. The MPCC's jurisdiction was heavily constrained by a series of challenges from the government, upheld in part by the federal court, about how far it could go investigating the actions of others, not beyond the MPCC. Their whole point was, in light of what instead of military police, the whole point was, in light of what military police knew, was there a dereliction of duty? And going outside of that question was generally what the court said they couldn't do. To the credit of the commission, there's a lot in that judgment that talks about the context, the systems of information, where knowledge would have come from. And the emphasis ultimately is on military police may not have had the knowledge or the information to make the judgment that they would be aiding and abetting in torture. But they left it open with a big, big pregnant pause that others in the system further up who had that knowledge could well be judged differently. And that was not before the Military Police Complaints Commission. So it's important to know that bit by bit, books like The Savage War and everything else that Murray has written and knows that probably still hasn't, everything's still not come to print.
It's crispy home.
Yeah, that's right.
Yeah. The freedom of information, information that does come out over time, Amir starting the ball rolling, order paper questions that NDP and on occasion Liberal MPs have been putting in over the years. There is a growing mosaic that will allow the story to be told in a way that anybody who's open-minded about how the real world works will understand.
May I please add a bit? One thing that I didn't say, which I now regret, and I will say, is our experience in Canada, when I called our courts having behaved cowardly on this point, let me put it into comparison for you. In the United Kingdom, precisely the same lawsuit as we did was brought. Exactly the same lawsuit by a peace activist named Maya Evans. And I worked closely with the legal team there that brought that lawsuit. They were seeking an injunction on detainee transfer. They won. And the government didn't even appeal the decision. They accepted it.
What happened then?
What happened then? Well, the court ordered that detainee transfer could only happen to a few NDS facilities where there wasn't evidence of torture. So the number of facilities was greatly reduced. And in a later case called Sardar Mohammed, which was decided only October, November last year, this is where it got really interesting. Sardar Mohammed was a British detainee who was transferred. So it was possible to track him down, and it was possible to obtain a statement, affidavit evidence from him. Murray's right, this will be very difficult, but this list does exist.
It does exist.
And eventually it will come out. And you know, it may, despite the difficulties Murray is quite right to point to, it may be possible to find a detainee. The British have done that. And when Sardar Mohammed's case went to court, here's the punchline, the government conceded it and said that the remaining NDS facilities too had torture problems. Compare that. The Conservative government, the Conservative defense minister in the UK instructed counsel to say, go into court and concede. Yes, we have torture problems. And so as of November of last year, the British do not transfer anymore to any NDS facility. Our government has fought it tooth and nail. Mind you, those are two court decisions, including a flesh and blood detainee in one case, the latter one, that were never even appealed. And in our country, it was appealed to the top, and the top turned turtle.
Just to follow up on a point that Amir had made, the transfer of prisoners to NDS custody or Afghan custody by NATO ceased in the summer of 2011 prior to a report by the United Nations which spelled out in graphic detail that there had been, and there continues to be, torture in Afghan facilities. It was only at that point that Canada decided that they were not going to transfer prisoners. There were still a few that Canadian forces were picking up at that late stage of the game. And it was at that point in the summer of 2011 that the Canadian government began negotiating with the United States to hand over prisoners to the Americans and where they would be housed at Bagram, which there's been a lot of talk about Guantanamo here, but there has been very little discussion, very little public discussion in this country or even in the United States, as far as I'm concerned, about Bagram and about what has gone on there. There are allegations. There was a fixer who worked for both the Globe and Mail and for the Canadian Press and for CTV, a local journalist by the name of Yasmin Yazmi, Jojo, and he was captured and declared an enemy combatant by the United States and sentenced to Bagram for 11 months. He claims to have been tortured there. So there are many questions, and I understand when Amir says, like I wanted to underscore the point in my presentation that how difficult it is and how conflicting. I don't want to leave you with the impression that finding the evidence is impossible, but the circumstances in southern Afghanistan, even today, are going to make it incredibly difficult, and it's going to have to be something. I don't know if peace is ever going to come to that land, but it's going to have to be something where you're not trying to chase these people down in the middle of a conflict situation.
And if I could abuse the prerogatives of chair just a little bit further, I mentioned something called order paper question. In our parliamentary system, what you're all used to seeing is the 50 minutes of question period, which is the oral questions where somebody stands up and has maximum of 30 seconds and the responding member of the government, often not the minister who stays in his seat, has 30 seconds to a minute to respond. There's also written questions. They're called order paper questions. And MPs are allowed to be putting in 4 sets of order paper questions at any one time, and these questions can be subdivided. So, in fact, you can sometimes get an awful lot more down by way of question and response back than ever happens in question period. So, in terms of a number of order paper questions I've been submitting on the Afghan issue, and more will be put forward in the future. One question I asked and got a response to in September had to do with the report of the panel of arbiters that have been set up as a brokered process when Parliament was trying to get access to the documents. The panel of arbiters was set up as part of an agreement that the Bloc, the Liberals, and the Tories agreed to. The NDP didn't. That would allow 3 ex-judges, 1 died, so 2, to vet documents to decide what then could be made public to Parliament. By and large, most of the ones that had redactions remained redacted after the panel of arbiters reported on half the documents that they had received because Mr. Harper shut down the process after winning majority. Some of the documents, a large number of the 4,000 pages, around 200 and so documents, if I've got the number of documents correct, are actually transferred detainee records. They actually have names, and they have places, and they have some context of people who transferred by Canada to National Directorate of Security. All of those remain redacted. We don't see the names. What you saw there is an example. So my question to the government was, with respect to that information, those redacted detainee records, have they ever been provided unredacted? to any Canadian government law enforcement investigators for purposes of tracing the detainees named in the documents in order to determine whether any suffered mistreatment after transfer to Afghan's National Directorate of Security. If not, why not? Here's the identical answer from the Honorable Peter MacKay and the Honorable John Baird. Quote, the Department of National Defence and the Canadian Forces did not provide the documents referred to in the paragraph that had to do with listing detainee records to a Canadian law enforcement agency for purposes of tracing the detainees named in the documents in order to determine whether any suffered mistreatment after transfer to Afghanistan's NDS. So just repeating my question with a negative. Here's the reason. Quote, Canadian law enforcement agencies would not have jurisdiction to conduct an investigation of Afghan officials, nor would such an investigation have been appropriate in the context of our relations with the government of Afghanistan, unquote. That tells a whole story right there about the dynamics, the point of view, and how the system was acting in a way to invoke closure at the other end in terms of making sure as little information as possible is available for the kinds of purposes we've been talking about on this panel. Sujit?
Hi, my name is Sujit Xavier. I'm a graduate fellow here at the Nathanson Center, and I'm a PhD candidate. My first comment is to Professor Attaran. Excuse me if I'm going to be polemic, but I'm really surprised that you're surprised. Given the culture of Canada and its colonial history and what it's done to its Aboriginal population so far, why are we surprised that the judges have this particular culture? And in light of what's happened to the Japanese, which I think someone alluded to earlier in the morning, you know, this is Canada's history, and it's history repeating itself. And I just want to maybe provoke a bit and say, I think maybe we should get off our high horse and stop thinking of Canada as being this entity that promotes human rights and, you know, democratic values, because I think there are much larger things at play, such as, you know, geopolitical issues. That's just the comment. Now, in terms of the question, it goes to the two professors from the Canadian Forces College. I was absolutely fascinated by your presentations, and I just want to know if you can talk a bit more about the curriculum that you use to teach the soldiers. And so far, within the current academic context, we have engaged in this interdisciplinary approach to teaching law. And so I wonder if you can perhaps shed a bit of light on whether you're using interdisciplinary insights as you teach the soldiers, perhaps, you know, teasing out certain historical contexts, anthropological insights, et cetera, in how they might encounter the dark, you know, colonized spaces that they might go into. Thanks.
I'll say a little bit. Well, first of all, let's say that I should let you know that as professors, we have contractually guaranteed academic freedom.
So only on our areas of expertise.
In our areas of expertise, yes. Which we like to define broadly.
I'm here to keep them out of trouble.
And so that also includes our advice on designing the curriculum, and indeed on our speaking here today. But certainly, I feel like I'm testing that academic freedom by what I said today. I chair the Department of Security and International Affairs. We're responsible for that curriculum within the Canadian Forces College. And so issues relating to the overall sense of security and international affairs. And we do encourage critical thinking. So we ask them to look at the pros and cons. Chris will tell you more about how we do some case studies on the legal side, Breaker Morant, going back to years ago as to a sense of justice. In my case, probably one of the more provocative things that we do is we give the students a choice of essays. And one of the essays they can write about was Eisenhower's military-industrial complex. And indeed, I found a U.S. student, we have students from 20 countries at our college, wrote a brilliant essay just a month ago on Eisenhower's military-industrial complex. So, I mean, I'm fairly proud of the ability that the Canadian Forces has given us, the freedom they've given us to be able to explore academic subjects and be able to speak out.
Yeah, I would say that the issue is really culture, and that's the military culture. Most people in the military are good people. The only problem with Afghanistan is that bad policy and a bad war has a tendency to turn good people into bad if they're faced with complex situations or make bad decisions. What we try to teach at the college is critical thinking and to look at beyond just the standard predictable response. Walter's in charge of sort of the higher strategic side of it. This side of it now, I'm in charge of really operational planning, military planning and operations. I'm paired up with, last year it was a infantry colonel, this year it's a US Air Force colonel. And we are responsible for all the curriculum in the college in that area of expertise in terms of operational planning. Operational planning, I would think, is the forte of our college, particularly for the majors and lieutenant colonels course. Legal curriculum was a very big part of the legal curriculum when I was first there, largely because there was a gap in what was being taught. It has become progressively less so. I would say there isn't really an anthropological or sociological focus to it because the military is still struggling with the legacy of Somalia. They're just starting to talk about it now, never mind Afghanistan. Afghanistan will probably be a subject 10 years from now. The problem is that we have people that have just come out of Afghanistan, and we have people that handle the detainee policy or implement the detainee policy that have very strong views on it and strong views of their performance and their track record in that. Trying to dissuade them from their preconceptions and assumptions and all sorts of other things is one of our challenges. But again, because of the environment, most of the legal curriculum, I would say, is taught by the military legal officers in terms of content. The military legal officers have a very set perspective on these types of things, and even some of those military legal officers were involved in the federal court defenses of the challenges that were taking place. And in fact, two of them actually got awards for their conduct in winning the federal court. You know, he may have lost it, but these two officers, military legal officers, considered that they won it. And you know, a lot of the military officers get awards in battle. Two of them got awards for winning that court case.
Battle in court.
Yeah, battle in court. Yeah, again, militaries, in general, I think armies have the propensity, in the past, you can look at the Eastern Congo right now, armies will rape, pillage, kill, destroy if they're undisciplined and aren't under good leadership. We hold our armed forces in the West and Canada here to a higher professional standard. We try to instill the rule of law into them. That's very good in my opinion, but it's not perfect all of the time because of the nature of the activity that they're engaged in and the complex situations that they're placed into, and also the higher policy and political direction that's being given to them. Often there is no political direction. They're simply told to go off and do something in a very complex environment, and they're making up their policy along the way. It's interesting because we talk about Somalia legacy and having the record of all this. The Somalia inquiry, you know, there's the published report of the inquiry, but they actually issued a compendium of all the raw data, all the raw documents. You actually need a Windows 95 computer now to actually read the thing, but you know, it's all there. It's all there, even though it was shut down and truncated. They put all the data onto this disk, and you can go read for yourself and make your own conclusions about what happened there. The military actually had a board of inquiry into the Afghan detainees. All the raw data is all in the appendices. You know, you can read the report, and the report's very vanilla, justifies the actions that were taken on the part of the senior officers in the military police and the more junior people.
Chris, there's a second report.
Yep.
has been taken down offline, which
Yeah.
is a lot more critical.
Yeah, well, that's what, I understand the theme is of this is sort of access to information. And, I find even, I'm sort of a privileged insider-outsider when it comes to courts-martial. But the chief military judge has started to take down the courts-martial. They used to be back to the 1990s. I think you can access up to 2004 right now. I actually got them to send me all the decisions between 2000 and 2004 so that Carswell could actually put them into their system. But they have a sort of moving goalpost on sort of information because they just don't think that the public or academics will be interested in it at some point. For historians like me, I'll always be interested in it and want the information. But again, the control of information is one of those issues with the military.
Anybody have any further questions? I was wondering if not, Murray, if you had anything else. Oh, yes.
Good afternoon. Wonderful panel. It's been a wonderful day, very informative. Elizabeth Curley, Switzer, graduate student here, chugging away at my doctorate. Also teach at Ryerson in security threats, criminology. A couple of years ago, for 3 years, I worked with a member of the teaching staff at Canada Forces College with Eric Ouellette to do a D&D study on the growing collaborations between military and police, law enforcement. And my job was to talk to police officers across Canada, RCMP, provincial police, and Sûreté, and municipal police, and find out what their major complaints were or what they saw as impediments to collaborations, particularly in the security environment. And I noticed that we really are talking about evidence today. So I've narrowed in on one question. I'm particularly interested in caveats. That came up again and again in the interviews. Police officers were very resentful of caveats that were used by the military to excuse their personnel who were involved in joint or integrated security units or joint force action from going to court and testifying primarily, or for actions on the ground in Afghanistan. And I'm just wondering if either of you gentlemen, Dr. Dorn or Chris, if you have any comment on caveats and if you run across that particular device, that what I call a tool of exception in what we're talking about, being used more as a shield.
Very briefly, and probably the other panelists have something to say too. Then you're talking about national caveats, that the different forces place national caveats on how they're deployed in Afghanistan?
I'm talking about, well, I haven't heard them referred to as national caveats.
I think she's talking about jurisdiction.
Yes, I'm talking about jurisdiction.
Okay, then I'll let other people speak to that.
Okay.
I can say a little on it. When I represented as counsel a former translator in Afghanistan named Ahmed Shah Malgarai, also known as Pasha, testified in front of Parliament. He testified in a parliamentary committee to the effect that he had been present at detainee transfers where threats of force abuse were uttered by the NDS. He testified and indeed answered questions about a document that that essentially had been written by a Canadian intelligence officer that in essence said, the above 6 detainees haven't been cooperative. We recommend sending them to NDS, quote, for further questioning. He had translated documents like that. He had a fairly good inside view. After he testified in Parliament, the Military Police National Investigation Service got in touch and said, we'd like to interview your guy and investigate his allegations. And I said, that's lovely, but my client doesn't trust you. Why would he? You're the same force that didn't do anything about the torture, and now you're going to investigate his allegations that there was torture going on, so he doesn't trust you. What we would like is that an outside police force
be brought in to conduct the investigation. Toronto police, for argument's sake, I don't know, Chiretier, somebody like that. And that was refused. So the military was unwilling to let an outside police force investigate, and in consequence, my client was sharply criticized by the NIS as not having helped their investigation and standing in the way of the truth and rubbish such as that.
I guess the only thing I could possibly add to what Amir said, if I understand your question correctly, you're talking about some of the caveats that involved operational mentoring and liaison teams when Canadian Forces members served directly alongside Afghan soldiers on joint operations. Yes, I did hear actually complaints from some of the Canadian police officers, one RCMP officer in particular, about that. And the way it was explained to me is that when the Canadian Forces go into the field, they have a certain set of rules, ROEs, rules of engagement. And even when there were partnered in joint operations, Canadians were subject to their own ROEs. The Afghans have completely different ROEs. The Afghans have completely different rules of force. And essentially, the way it was explained to me, and this I'm going back to 2009 because that's when I first heard the complaint. Essentially what I was told was that that caveat was in there because they were operating with Afghans who had different rules of engagement. And it does pose not only a legal but an ethical dilemma for soldiers that were in that particular case. Was I able to get anyone to speak on the record about that? That's a completely different matter. And I did come back and file access to information requests. And of course, you see what the result of it is. It's just, they were buying black ink by the gallon at DND. So I hope that answers your question. But I mean, essentially, I'd heard the same thing, and but that was the explanation that I was told.
Can I add something?
Often these caveats are set by the higher headquarters. Back then, it was the Canadian Expeditionary Force operations headquarters. It's now all one joint operations headquarters in Ottawa that handles. There's a distinction between domestic operations, which the military, when it's employed in Canada, is very much in a supporting role. And so there's sort of a tradition or body of experience that the military has kept in formed bodies, but they're put under police control, usually for some sort of, whether it's natural disaster, riot, prison breaks, whatever. So there's I guess, an experience with the police having the military under control that is different from when the military goes abroad, where the military has the lead on many of these things that the police would normally have the lead on in the domestic sense. So it's, in part it's structural and in part it's cultural. And this, one of the things that Attaran and the court case really showed is that the military police, the military police are responsible for the investigation of these type of things, but under the military structure, the military police are actually the people that are responsible for the detainees too. And one of the complaints for the Military Complaints Commission was that they were investigating themselves and trying to look into actions which ultimately they were responsible for. And not only are they responsible for the detention of detainees, but under Canadian military doctrine, they're responsible for the interrogation of detainees as well. So it's more of an inbred type of structure. They've corrected some of it with the creation of the Canadian National Investigation Service post-Somalia, but again, it's a very small community for the military police, so it's hard to distinguish between all the training that they've had in detainee handling and interrogation to suddenly say that they're independent investigators and ultimately have the power to lay charges on many of these things. As I say, most of them are good people, but it's hard to put aside your training and background because the military exists to acculturate and make sure that people respond in the predictable consistent way. That's just the way that they're and in fact, they're trained to think alike too, and trained to think in a certain way. And that's one of our challenges, is trying to push them out of that very comfortable mode of thinking.
Okay, so I'm going to exercise the chair's prerogative and go over to Colin and then Ron and then back up. And then we'll have to...
Yeah, just a quick follow-up on something you said, Craig. I think just about the lack of criminal investigation to Afghan detainees, or the rationale for why. I mean, I don't think you have an answer to it, but that's confusing, because post-Arar inquiry, post-Arar settlement, there was at least, I think, a perfunctory RCMP investigation in 20. Canadian officials could be criminally culpable for any of that. It didn't go anywhere, but nobody slammed the door on that from the outset by saying that would be embarrassing to our relationships with other states. So as a rationale, I mean, it obviously doesn't wash, but I'm a bit surprised. I don't know. Are Canadian police obligated to investigate torture as a matter of discretion, or what's the law, basically?
Keep in mind, there's two things going on here. One is a sleight of hand. They're pretending they didn't understand my question, so that it's as if I was asking them, were they investigating Afghan officials, with the only issue being whether Afghan officials are guilty of torture, when of course the question is whether or not Canadians might be involved in aiding and abetting the torture done by Afghan officials. And so there could be an element of that deliberate kind of sleight of hand. The other thing, though, is I guess don't look for great consistency across any given government, especially over a period of time. Right from the beginning, General Hillier in particular was the biggest invoker of this whole idea of Afghan sovereignty as just the ultimate reason why the MOU had to be so watered down, why he didn't really see it as all that necessary until he suddenly looked like he was becoming enthused and ended up signing an MOU that was very watered down. But the idea of the affront to the dignity of the Afghans through this notion of Afghan sovereignty in a context in which the laws of war, Geneva Convention number 3, actually say that if you transfer, this is an international conflict, mind you, that if you actually transfer a prisoner and then you learn that there's been abuse, you not only have a duty to sort of speak out, you have a duty to go and get that person and extricate them from the situation. So if the laws of war already have no problem with infringing another allied army's sovereignty, how does it have such a hyper existence in Canadian discourse?
Just to clarify, sorry, was your question investigate at the Afghan jailers or investigate Canadian who are complicit with the Afghan?
The question was about the latter, but in order to find the people who might have been victims, that was the whole issue. Did you even go look to see if there are any victims? No, we didn't, because it wouldn't have been appropriate.
And just to add something on that, I mean, this was also, to some extent, the Federal Court of Appeals ruse, was to say that, you know, the Charter couldn't possibly, Canadian law, the Charter couldn't possibly apply in Afghanistan. That would infringe their sovereignty if it did. Well, Canadian law does apply to Afghanistan. I mean, we pay the soldiers, right? So the Financial Administration Act, I guess, applies. You know, if the soldiers were to do something horrible and engage in a service offense, the National Defense Act would apply.
Criminal law.
And criminal law, right? So here's the irony of the Court of Appeals and the fallacy of the Court of Appeals reasoning, that to apply Canadian law, abroad, to these Canadian officials abroad dealing with detainees, it's not allowed when it's the Constitution, i.e. the Charter, but if it's a minor regulation under the National Defense Act, it is allowed. So it turns the hierarchy of laws on its head.
Well, it's just inconsistent because the criminal law applies as well. There's no sovereignty problem.
The highest law of the country does not apply abroad, but our lowest law does. So, I mean, thanks.
Yeah, to be fair, I was very surprised when Hillier signed that MOU. And I was surprised that it wasn't the Minister of National Defense who actually signed it, because those type of orders are generally passed verbally. Because essentially what Hillier was saying was that he knew for sure that people weren't being tortured or had enough confidence that they were being tortured. It's very rare that you get a senior officer that would actually put down in writing their signature to do that.
Okay, so Ron, and then...
Just a couple of very naive questions. The judges in the dying days of the minority government who had access to all the information. Have they spoken out, or what is their position? Are they still duty-bound not to disclose any of the information? And secondly, where's Richard Colvin, and has he survived this whole situation because he was the initial whistleblower?
Well, I mean, I can say a little something on that. Remember that the judges were not judges. They were lawyers. They were ex-judges, right?
But they were appointed because they were judges.
Of course, but at the time they were appointed, they were not judges.
But they took an oath?
It's not a question of the oath. It's a question that they were acting as lawyers. Yes, they were ex-judges, but they were acting as legal counsel, meaning they had a client, and they have a duty to that client, as any other lawyer does, known as solicitor-client privilege. And so if they were given instructions to say nothing, they must say nothing.
But that may be, I think we're going to have to look into, former Justice Iacobucci was the government lawyer at one point. So he, in the sense that he was called in to start looking at the documents, and that raised a bit of a furor because, you know, it was one way the government was trying to delay and to cloak a bit. But then he was one of the 3 judges appointed to the panel of arbiters. Right. And what I'm not sure about is whether or not they were formally brought in under a sort of a legal engagement by Parliament, by the government, or whatever. But the point is, the whole process was cloaked in oaths of confidentiality. I don't
why
expect...
don't you ask for their retainer agreement?
Yeah, thank you. Good order paper question for me. Thank you, I will. I will. And what was the second question?
Richard Colvin, where is he and what's happened?
Richard Colvin is still in, well, he's not quite, he's almost retired now.
He went to Washington, right?
But did he suffer any
in Washington.
severe career path deprivation?
You'll have to read my book. I have an interview with Richard Colvin in the book, but essentially it's fair to say that his career within DFATE was over.
Thank you.
It went sideways. Mr. Colvin is now, he's still with the Department of Foreign Affairs and living in Ottawa at the moment.
So I'm conscious that we're significantly over time, but we also
we probably should end, yes.
Yes, but we also started a bit late, so I'm helping myself.
Well, then are you going to ask a question? Or you're just...
An opening and a question. The opening is in response to Amir's suggestion of the time capsule. I actually like this. And at the Nathanson Center, we try to have databases of things like this. The case of Abdul Razak, for example, is documented on our website. Now, 4,000 documents, I don't know if we have the server space.
Oh, it's all, the CBC has it, Globe and Mail has it, all that stuff is
okay, but in terms of mounting a full-time capsule, I'd like to volunteer the Nathanson Center as being part of that effort. And I think that effort should be public for researchers and journalists for years to come to look at. So that's the opening. The question is, given the expertise on the panel, what's really the state of play right now with respect to detainees transfer? As in, of course, Canadian government says, well, we did the necessary inquiries, and therefore there's no really any problem here. Yet the Committee Against Torture says, yeah, well, we record this, but he said the committee is concerned about several reports that some prisoners transferred by Canadian forces in Afghanistan into the custody of other countries have experienced torture and ill treatment. Do we know anything about these other countries? Are they referring to the US, or is that something else? And in terms of policy changes, I can see that any policy changes might be interpreted as an admission of guilt, but as anything happen, to say, well, you know, we really don't want this to happen internally, in terms of what you know, because we're hearing about other countries like Mali. We're not, perhaps not in it right now, but who knows where we'll be next week. So could that be, given what we have right now in the attitude, something that, you know, reiterates itself?
Well, essentially what I can tell you is that as far as Afghanistan is concerned, the MOU that was signed between Canada and the United States still stands. So there are 950 Canadian soldiers that are training Afghan forces in the Kabul and Mazar-e-Sharif area. And they're under strict instructions, the last that I heard, which would have been just a few months ago, to, if on the very, very off chance that they were going to capture a Taliban prisoner or a Haqqani network prisoner, they're under instructions to hand them over to the Americans. And as far as any future missions go, I guess there are two things that I would have to say. The first thing is I'm hopeful that the government has learned its lesson in terms of how it negotiates and what it puts into arrangements if they indeed, plan some kind of military operation. The second point is that I would suggest to you that you're saying who knows where we're going to be tomorrow. I would suggest, at least from my reading of the tea leaves in Ottawa, is that the experience of Afghanistan has so scalded and burned this particular government that you will not see Canadian troops deployed in a combat role or in any kind of substantial role for a generation.
We actually do have clear standards. They're in the Geneva Conventions, which we have implemented by Act of Parliament. The official position is that Common Article 3 will apply even though we withhold status from them. So that essentially detainees get all the privileges and protections of Common Article 3, but they don't get the status. And we actually do have prisoner of war determination regulations, but we've never applied them for the last 15 years. The prisoner of POW determination regulations say that you actually have to have a legal officer that has review boards to determine whether they're POW or a detainee. We just treat as for status as de facto that they're going to be detainees. That's where we get into all the problems, because if we applied the Geneva Conventions and treated them as POW, then we would have very clear standards of what the expectations are. But that gets back to the policy and the government's stance on operations like Afghanistan. I don't think this government has ever even admitted that we were involved in a war in Afghanistan. We were there lending assistance to a foreign power, in the same way in the domestic sense that we lend assistance to a provincial or municipal government. They were just treating this sort of extraterritorial assistance somewhere else to another government. It comes down to the language and the status, and we're probably not as bad as the United States because they have all sorts of different designations for what these people are. But again, Common Article 3 is the common one. That's what the Canadian Forces trains to. I don't, in terms of getting into another operation, I think it's going to come much sooner rather than later. I would think that the type of operation that we're going to get involved in is another type of Libya operation instead of an Afghanistan operation, where the emphasis will be on maritime power and on air power. That doesn't get you away from the detainee issue, because as was mentioned, the Canadian warships still take detainees in the normal course of business, not normal course of business, but on deployed operations. They have a catch and release policy, essentially, where they take all the guns away from the people and put them back in the boats and let them row the shore or motor the shore. That's probably a better policy. The Chinese and the Indians just show up and they simply blow the boats out of the water and let them swim back. But again, it's a more enlightened policy for the situation which is there. The Indians and Chinese in the Indian Ocean are considered cowboys. You don't want, their attitude to drive the pirates away is simply to blow them out of the water and prove that they're real regional powers.
There's a couple of things to add, and I think we probably, unfortunately, going to have to end with this. Keep in mind that even though when we took over in Kandahar, it was a handover effectively from the Americans in very start of 2006. We had been there before we left, we came back. The Americans didn't go away. They still had a presence in Kandahar. And so the whole question of whether all detainees ended up only with the Afghans is a very good question. Let me just put it this way. It's a very good question to ask. And the answer will be very interesting at some point. The other thing is, we shouldn't assume that we necessarily have a bead on all of the people who, let's put it this way, moved from being captured into the hands of the Afghans simply by using the term detainees. There might have been other categories that weren't necessarily categorized as detainees. And the second Board of Inquiry report, the one that's disappeared from the web, hints at it, that there might have been a category of capturees who didn't rise to the level of detainees. And then the other method that's used, could have been used as a method, but also just happened to be the reality of warfare, was that in joint operations with the ANA, the Afghan National Army, you would quite often, when the time came to take custody, well, would the Canadians take custody or would the ANA take direct custody? And then what happened, right? So I don't think we have a full picture of, let's call it the capture and transfer process, if we only focus on what the current government calls detainee transfer.
And it's important to distinguish, we do have special forces employed all over the world right now in deployed operations, the Joint Task Force 2. But special forces are subject to the same requirements under the law of armed conflict as the rest of the Canadian forces. And certainly they, we don't know, but we would assume that they would be detaining people and transferring them to other foreign powers because they don't necessarily have the capacity to hold those people.
From 2006 on, for at least, Murray would know a lot more about this, so he'll correct me if I'm wrong, at least for a certain period of time, our special forces and American special forces had side-by-side facilities.
Yes.
Graceland and Gecko, right?
Yeah. Yeah, they're located, co-located very, very close by.
Yeah.
It's also interesting to note as well as when the MOU that was signed between Canada and Afghanistan, there was a staged implementation to the handing over of detainees. And I have it under access to information and documents that show that the Special Forces were the last to agree to it and the last to implement it and had reservations about the policy.
And with that tantalizing detail, let us end. And Francois, do you want to take us out?
Yes, well, I just want to say thank you for everybody, to everybody for attending. It's our third forum on torture within the last 5 years. The way things are going, given what we've heard today, my feeling is we might have another one, not so, hopefully not so soon. But until then, thank you very much, and tell people about this. It's going to be on YouTube. Hopefully a lot more people than were here will be able to watch this, and that we're going to continue to have discussions around this here at Osgood, and we hope that it's going to stimulate debates elsewhere, wherever that might be. So thank you very much.
Thank you.